Hey everyone, welcome into an all-new episode of Plan on It with attorney Christopher Botti, the board certified specialist in estate planning, trust, and probate law. I am your host, Mike Leon. Chris has more than 30 years of experience helping individuals and families plan for long-term care and protect what they've built. And in today's episode, we're going to be talking about, I'm sure, something that Chris gets asked a lot about, and that's incapacity planning. Chris is going to explain powers of attorney, advanced directives, how it helps families stay in control when someone can no longer manage their own affairs. Chris, it's good to see you as always, my friend. I want to ask you at a high level here because when people think of estate planning, they always think, oh, I'm dead. So what's the difference? But this is the other part of it, right? Incapacity, right? It happens to a lot of families out there and they don't think about it until it actually happens to them. Can you kind of explain what incapacity means in the estate planning context and why it matters too so much in the state of California?
Well, absolutely. Thanks, Mike. It's good to see you. So basically, estate planning involves planning for death, which is 100% certainty. We're all going to pass one day, so we can't avoid that. And that's what most people think when it comes to estate planning. I got to prepare for my demise. But a huge component of estate planning is also preparing for incapacity. And statistically, there's roughly a 50% chance that before you pass on, you're going to cross a line. And that line means that you're no longer going to be able to manage your finances or make medical decisions for yourself. And so that's incapacity. You're going to need help from somebody else. And so it's a pretty significant risk. And planning in this context involves dealing with those issues. So you basically empowering people that you choose to step in for you if you are incapacitated, to manage your finances, to make medical decisions for yourself.
Well, Chris, let's break it down. So what's the legal authority behind the power of attorney? What does it give someone, and how does it kind of help families avoid court involvement if somebody can't manage their own finances?
All right. So the court involvement that you're referring to is called conservatorship. Basically, it's a procedure in the California probate court system that's designed to deal with people who fail to exercise their rights and plan ahead and put in place through a series of documents people to take over their finances as well as their health care. So in California, we have what they call a durable power of attorney for financial purposes. And the main purpose of that document is to appoint someone as your agent who can sign your name. It's that simple, and act on your behalf to be able to manage your finances and take care of those finances for you in the event of your incapacitation. So that's a really critical document. With that document, you can avoid what they call conservatorship of the estate, which is when someone has to step in and manage your finances.
And what about on the medical side with respect to medical decisions? Like talk a little bit about the advanced healthcare directive. What does that allow someone to do? How does it, kind of ensure that a person's wishes are respected, those that are incapacitated?
That's the medical side of things. And so that's called conservatorship of the person. And so with the advanced directive, you basically have the ability to appoint an agent. Think of this person as your healthcare advocate, because that's essentially what they are. And they'll step into your shoes and act on your behalf. And they have the power to make medical decisions for you. And so, for example, if you're not getting proper care from the current physician that you have, the healthcare agent can terminate that relationship and find another physician to deal with the situation. They could also, put you into any type of program that you might need, fight with the insurance company if that's what it takes. And so the person you choose as your agent is a really important decision that you make. And that person, think of it as your advocate. And they're stepping into your shoes because you've lost your voice. You've lost your ability to communicate, give consent to treatment, refuse consent to treatment. So the big part of the advanced directive is the power to appoint an agent. And that really rises to the level of someone who actually can save your life because they're acting as your voice and being able to manage your healthcare decisions for you. So that's a critical component. The other component of advanced directive that most people associate with is the end of life stuff. When you're on life support, you have what they call a directive to physicians where you can have your agent basically, if you're reached the point where you've all hope is lost and you're on life support and there's no hope of having any quality of life, you can give your agent the power to say, you know what, please let this person go with dignity, and they can remove life support. So it can save your life and it can take your life. It is arguably the most important document you can have in the entire estate planning arsenal.
Chris, before we get a little further down the trough, and I'm going to ask you about some trust and how that kind of brushes up against this stuff. Like, can you kind of give some real world examples, client examples, obviously without sharing intricate details, but like where a family you worked with proper incapacity planning either prevented complications or maybe ones that didn't have a plan and it made the situation difficult?
When you do estate planning properly, it's a series of documents that work together. And so it involves both planning for death and planning for incapacity. And so we've had clients, for example, who have had come to me after the initial diagnosis of Alzheimer's disease, whether it's a single person or a married couple. And so with that in mind, we say, okay, let's look ahead because this condition is going to continue to erode your abilities to the point where you will cross that line and need help. And so putting these documents in place early on in the process gives the family peace of mind, which at the end of the day is what estate planning is all about. So that when they do cross that line, that someone could step into the shoes without court involvement and manage the finances and the healthcare decisions. And so we see that after that line's been crossed, the family will reach back to us and say, I'm so glad we did this planning when we did it, because now I'm in a position to, deal with the situation, protect my loved one, and not have to get the courts involved, keep it private within the family. And that's really important because conservatorship is an expensive process and it's time consuming, and we want to avoid that at all costs. And with the proper document, you can eliminate that risk entirely from your life. And so the best comment I can get from clients who are dealing with these issues is the documents worked as planned and it just went well. And we were able to step in and help this person, and the peace of mind was off the charts.
That's great to hear. And Chris, let me ask you, because I alluded to it before about power of attorney and then how it kind of brushes up with revocable living trust and things like that. Like, how do they kind of interact with each other? And does a complete plan need all of them working together?
Well, certainly if you have an estate that would go through probate, we've talked about probate in past podcasts, then the living trust should be the centerpiece of that plan for the purposes of avoiding probate. And in that living trust will be certain assets. And your successor trustee would be the one you appoint to take over in the event of death or incapacity. So a living trust has provisions in there to deal with incapacity. But the authority granted by the living trust to the successor trustee, who is the person who takes over if you're incapacitated, that authority is only over the assets in the trust. So it's not a complete authority of all financial purposes, because there's a bunch of assets you can't transfer to your revocable living trust. And there are financial functions that involve assets that are not part of your living trust. So you need that power of attorney to close that gap, to give that person you put as your successor trustee the power to deal with all the assets outside the trust and all the financial functions outside the trust. Together, both those documents working will eliminate the need for what they call conservatorship of the estate. So it's two documents working together synergistically as part of a plan that's where you get all bases covered, not just the trust assets, but the non-trust assets.
Chris, let me ask you, in your experience, what have you seen that tends to kind of cause confusion or create confusion for families when there is somebody declining, right? In that situation that you gave before, somebody got the diagnosis, but maybe they haven't been formally found incapacitated yet. Like what tends to create the confusion for them?
Well, there's a spectrum, right, of incapacity. You start off early on in the process, and you might be more vulnerable to manipulation, and so the family needs really to step up to the plate and monitor the situation. And at some point, you'll cross that line, and those documents will kick in. So the biggest mistake you can make is waiting too long. Once you've crossed that line and you've lost legal capacity, you cannot prepare a living trust, for example, or a power of attorney or advance directive. So the key is to recognize the situation early on and say, what can we do now to legally put us in a position to navigate the future? And so the biggest mistake that people make is waiting too long. And so you should address these issues right at the beginning, regardless of whether you're incapacitated or have a diagnosis of potential cognitive decline. People who have no issues whatsoever should still bake into their estate plan provisions to deal with incapacity in the living trust, along with the two powers of attorney, the healthcare directive, which is a medical power of attorney, along with the financial power of attorney. So it's really important that there's transparency involved, that your families are monitoring the situation and they recognize the problems and act as soon as possible to deal with them so they can navigate the future.
Chris, let me ask you on that front. Like, I know my understanding is California does have specific rules about who can step in if there's no documents that we've been mentioning exist, right? Like, can you itemize a little bit more? Like, are there additional problems that can occur when someone hasn't named agents in advance?
Well, the problem is that, like, basically there's two programs in California that are set up for people who fail the plan. One is for death, that's probate, and conservatorship is the probate proceeding that's set up by the state of California to deal with people who fail to plan for incapacity. And so when you're forced to go to the conservatorship court, it's a litigation process. So essentially, it's a really high burden of proof. It's what they call a protective proceeding, which means judges don't just willy-nilly declare people incompetent. You have to actually prove with doctors' declarations that this person truly has crossed the line. So the judges are extremely conservative. And because of that, because of the high burden of proof, it's an expensive process. And it also takes time. And so we've seen, conservatorship is a lengthy process. It can go on for, months because of the sheer nature of the process. And that is frustrating for families who need to make decisions immediately, whether they be medical or financial. And so it should be avoided at all costs. And what California basically says is, look, if you have in place a power of attorney and a healthcare directive, then you are in a position to be able to deal with all these issues you would otherwise be appointed as a conservator. And so you eliminate the need for conservatorship with these two documents. And that's really, really important because we don't want to have to rely upon the court system when, when someone gets ill.
Well, Chris, let me ask you, when people come to you and maybe they're a little bit worried about giving up a little too much authority, how do you kind of quell some of their fears there? Like, how do you help the family structure these documents?
Well, you want to basically put the people in place to act immediately when the time comes. Like, you don't want to put any barriers to them stepping in and managing the situation, whether it be financial or medical. So the critical issues that they have to decide is picking people they trust to do the job, right? And so that you're going to hold on to your powers of attorney. You're going to hold on to your advance directive until they needed to be deployed. So you're not going to just release those documents until they're ready to be deployed. And so the risk is really minimal when you choose the right people to make these important decisions, your healthcare agent and your power of attorney agent, and then let them know that these documents exist. And when the time comes, if needed, they can get them and deploy them. And so you're going to maintain possession of that paperwork and choose the right people. And with that, you have the peace of mind knowing that they're not going to step in unless you truly have crossed that line.
Chris, as we kind of put a bow on today's episode, what are some of the issues or some advice you would give to folks out there? Maybe their powers of attorney are outdated. They're a little too broad. They're too limited. They're drafted without that California specific language. What's a piece of advice you would leave to them right now?
Well, you got to take a look at the power of attorney and see if it's comprehensive. And so a lot of times people will get powers of attorney off the internet. They're very basic. They don't have all the critical provisions. They are not designed to work in conjunction with their trust. And so they should take a hard look if they have existing power of attorneys. Age alone is not a problem necessarily, although sometimes banks will push back on documents that are very old. The key is how comprehensive they are. And it's important that you cover all the bases with your power of attorney. And there's a lot of junk documents out there you can get for free on the internet. And you shouldn't rely upon those, because this is everything you've worked your entire life to accumulate. And the last thing you want to do is, because of a defective power of attorney, have an end up to go to conservatorship court because those powers are insufficient. So take a hard look at what you have. If you have any questions or issues about whether you think they're sufficient, have somebody qualified who's an attorney review those powers of attorney. And if necessary, you can take corrective action to update them or modify them so they will work when they're called upon to work. That's really, really important.
Yeah. I had an attorney tell me once, it's not about how many pages, it's what's in the pages, right, Chris? So, Chris,
context matters.
Exactly.
It absolutely does.
Chris, thanks for the time and the insights and breaking this all down for the audience. Appreciate it, man.
Thank you, Mike. Take care.
And that's it for today's episode of Plan on It with attorney Chris Botti. If you want to connect with Chris and the team, you want to get those power of attorneys looked at right now, do me a favor, visit boddylaw.com. One more favor before you go, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.